Okay, well thank you guys for being here. Welcome. We are here for the Getting Off the Risk Transfer Railroad presented by the American Subcontractors Association Bay Area Chapter. I'm Dan McLennan, your presenter. And let me offer you this. What I'll do is anybody who wants a copy of the slideshow afterward, just give me your card. I'll be glad to send it to you, or you can drop me an email. My email's throughout the presentation here. Just for those of you that may not have the handouts, it's dmclennan, DMCLENNON at mclennanlaw.com. Go ahead and drop me an email. I'll be glad to send you the slides. This is some information about me. I've been doing construction law for 25 years. I've got the nice AVO tag up there, got the 10 out of 10 rating, so I had to, pat myself on the back a little bit. But you can look at me about that later if you want to. All right, now what we're going to talk about today, we've got a big list of risks, legal risks to watch out for that would otherwise railroad you subcontractors by the general contractors and shifting risk to you. The big areas that we're going to talk about today is unfair indemnity to others. And that means that the subcontractor can be caused to protect the general contractor or an owner from liability for fault that they caused or problems that they caused. In the old parlance, that's the Type 1 indemnity, no longer allowed in California law. We'll get into that in some detail. Unfair insurance requirements is where the general contractor requires you, the subcontractor, to provide insurance for the general contractor that protects the general contractor for the general contractor's own fault. I'm going to argue that that's no longer allowed under California law also. Some controversy about that, as we'll see. And then other areas of risk to be on the lookout for is when an apartment building gets converted to a condominium. Oops. If you're a subcontractor and you've got your typical residential exclusion, that conversion just excluded you out of your insurance coverage. And that might happen 5 years after the job is done, and you've got an exposure you didn't even know existed. So anytime a subcontractor does an apartment building, you've got to be prepared to have that become a condominium project later on down the road. Uncompensated project financing. Owners and generals finance their projects on the backs of the subcontractors by having the subcontractors pay for the labor and material well in advance of any payment from the owner. You're financing the project, you ought to get paid for it. Scope creep means, well, you end up having a contract that's much broader than what you thought you were getting into when you actually signed the paperwork. Because there's wiggle room in the contract language that says, for example, your scope includes those elements of the project that are reasonably inferable from your contract. Well, what does that mean? And what's reasonably inferable to you may be less or more than what's reasonably inferable to the contractor. And so that's another area to look out for. Uncompensated labor and material cost increases. If you don't protect yourself in your contract for cost increases over the duration of the project, you may end up paying 20% more for the materials than you anticipated. If you got no place to go to push it upstream to the owner, you end up eating that. There goes all your profit and maybe some of your profit on other jobs as well. Uncompensated schedule inefficiencies. That's where the project takes a lot longer than you thought it would. You haven't budgeted for it. You don't have it built into your contract. If you don't have a way to get it out of the owner or the general contractor, again, that's a risk that you would eat it. Expensive warranty back charges. Does your contract make you on the hook for repairs? And does it give you the opportunity to make those repairs? If you don't have the opportunity to go in and use your forces and your efficiency to fix your things, and the contractor gets involved and hires somebody else to do it, it's automatically going to be at least 20%, 25% more expensive than the way it would have been handled had you done it. So your warranty callbacks or your warranty exposure can be a lot more expensive if you don't take care of that in advance. Okay, and then lastly, where we're going to end up is, and I need to make a pitch for the American Subcontractors of California, is that we have a bill presently pending in the California legislature. It's AB 164 in public-private partnerships. Folks, right now in the state of California, public-private partnerships are the wave of the future as far as public financing of public works jobs goes, because the government doesn't have the cash in the coffers to pay for these projects. And so what they're doing is combining forces with public entities, where the public entity provides, or private entities, the public entity provides the land, and then the private entity provides the financing, and then hires the contractors to do the actual construction. The public owner never becomes involved in the contracting for the construction other than the deal with the financing entity. What this means, though, is since no public funding is going into the project, there's no way you, a subcontractor, can put a stop notice on public funds. Well, what happens if the private funding entity goes out of business? If its funds dry up, there's no fund to put a stop notice on. Well, we could always put a lien on it. No, you can't, because you're putting a lien on public property, which is not allowed. You can't foreclose on public property and take which was dedicated to the public and use it now for your own private uses. So you have no security either in stop notices or liens on a PPP. And so what the ASAC has proposed, and is going through the legislature, is to make PPPs just the same as any other public works job. Why not have payment and performance bonds? And so that's what our bill proposes. So we're going to be asking the subcontractor community to come out in favor of this bill. And in fact, we've got a specific party just for you to do that. And on April 24, we're going to be up in Sacramento having a legislation day. And the structure for the day is in the morning that we'll have all the subcontractors and people that are interested in this bill come on up to Sacramento. We'll teach you in the morning how to talk to a legislator. Do's and don'ts. We'll give you the handouts. We'll explain to you all the bills that we have and the points to make. I remember being pretty intimidated the first time I went up there about 8 years ago to one of these ledge days. And once we got through the training session in the morning, I felt like, okay, I can do this. I've got a piece of paper. It's got everything on there that I need to be able to say to the legislators. And so we did. And what the group will do is we'll set up the appointments for you to go meet with your senator and your assembly person. From your own district, you can say, hi, I'm your constituent. I'm voting for you, and I need you to support this bill, and here's why. We set up those appointments for the afternoon. This is a highly effective way to get lobbying done. The more bodies that we have up there, the better. So I'm asking every one of you, please seriously consider committing to going up there on April 24. There's a registration package and a flyer and a lot of information about this on this ASAC website. So go ahead, click on there. It's ASA of California. Easy to find the website. Click on it. Find the registration form and sign up. Okay, that's enough of the plug for the ASAC. Let's go on and talk about how do you even get into the ballpark of being able to negotiate these risk railroading, shifting clauses that the general contractors try to push on subcontractors? Well, it all starts right with the bid. Contracting basics is, look, a contract is formed when you have an offer, an acceptance, and consideration. Well, here, a bid is your offer. You submit a bid to a general contractor to do a particular scope of work for a particular project at a particular price. That's an offer. Now, the general contractor, having your bid in hand, has the power to accept it and create a contract. If he accepts your bid, signs it, sends it back, you've got a contract. You're stuck with whatever it is that you put into your bid. Now, if you say, this bid is per plans and specifications, section, price, $100, and you've incorporated the plans and specifications, which, if the specifications include the general contractor's form subcontract, now you've got the worst of all worlds. You're stuck with the general contractor subcontract form. You can't negotiate it. You've given a price and you've given a scope. You've got no wiggle room. You're done. Contract is formed. Now, on the other hand, you protect yourself by conditioning your bid. Anytime a bid leaves your office without conditions on it, you're set up for failure. Absolutely, positively, every subcontractor's bid process should include conditions on the bid. Because now what the transaction transpires is when the general presents its form subcontract, you've submitted your bid, but you don't say per plans and specs, or you say per plans and specs subject to the conditions attached here too. Then when the general says, here's our standard subcontract form, sign it or else, you say, well, wait a minute. No, I don't have to sign your subcontract form because I never promised I would. In fact, if you want to use my bid, you have to send me a contract that uses the conditions in my subcontract form. So when the general presents its form subcontract, that's a counter offer. No contract is made at that time. In fact, there's no acceptance, no contracts formed. The bottom line is that you should condition your bids. And there's special language in the bid that says acceptance is expressly limited to the terms of this offer or other language. There's one exception to this. It's when you're bidding in public works jobs. If you put conditions on your bid that are inconsistent with the solicitation, then you run the risk that your bid is non-responsive, and so you would be rejected as non-responsive, and so you would be out of the running. So you have to be careful as to what the terms of the solicitation are. I'm assuming that in public works, the general contractor doesn't attach its form subcontract in the bid solicitation. So bid conditioning language is found if you're an ASA Bay Area chapter member. You get this for free. In fact, if you're not a member, you don't get it at all. So this is one of the benefits of being an ASA member. There's a list, bid proposal, updated in 2011 on the website. I've gone through it several times. In fact, some of the language that you're going to get here is right off of it. A lot of the ideas are right off of it. This is a wonderful tool for you to use. I don't recommend the language as written because no general is going to accept your bid if you had all this in there, because it's really lopsided and onerous and one-sided in favor of the subcontractor. But it is a good checklist of things for you to consider. And here, when you get the slide deck, you've got the download address right there. The ASA bid proposal incorporates the Consensus Docs 750 subcontract form. It's not widely accepted yet. Very few of the subcontracts that I've seen a couple, not very many use it, but it's a potential wave of the future. It's a very even-handed form, as most even-handed subcontract form that I've seen, and it's put together by about 20 different trade associations working together initially. Now it's endorsed by about 38 different organizations, and it incorporates your bid document as part of the contract terms. One thing to watch out for is that if later executed documents don't reference your bid, then your bid disappears. So you have to be consistent in making sure that your bid is carried forward. And here's some language about how to incorporate your bid conditions in the contract. I like this one in particular. Allowing the subcontractor to commence work or make preparations for work will constitute acceptance by the customer of this bid proposal. So if that's in your bid and then they say start, now you've got a contract that's got all of your wonderful bid condition terms in it. Okay, now we're talking about having the negotiation door being opened. This is especially powerful on public works jobs where the subcontract form is not specified in the bid solicitation and where the subcontractor writes a number of exclusions and conditions in the bid. The general, now remember, we're in public works. The general is calling the subs, give me your number, give me your number, give me your number. We fax over a number, but it's also got, here's your scope, here's the number, and, by the way, our exclusions and our conditions, right? This, folks, is your most powerful bargaining chip in a public works situation because, yes, the general contractor may bind you to your number, but he may not bind you to his contract. To the contrary, when he wants to get you to sign a contract, you've got all the leverage. Because you say, my conditions were part of my bid. You accepted, you want my number, you have to take the rest of it that goes with it. No, 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 we don't want your conditions, we want your number, but you need to sign our contract. You have every right to say no. Now this is an interesting dynamic about what happens. Okay, the general says, he submits his subcontract form to you, you say, we're not going to sign it. Then the general has a choice. He's got to either bend to your terms, or negotiate your terms, or he's got to go elsewhere. And we have, there's a case that just came down a couple of weeks ago where the general contractor said to the sub, you sign our contract, they refused, and the general sued the subcontractor for the difference in price because the general had to go out and replace that sub with somebody more expensive. The general contractor won on promissory estoppel, said, you sub, you cannot take away your bid number. But he didn't, the general did not win on the contract because the sub refused rightfully to sign the contract. And so the subcontractor was not bound to the contract, and in fact, the subcontractor was able to recover his attorney's fees against the general on the contract because the general didn't prevail on the contract. So, conditioning your bid gives you tremendous leverage in the negotiation. Now, there's that case. I think the subcontractor could easily have won on the promissory estoppel argument as well, but he didn't have certain conditions in the bid, which if he had there, he would have won on both the contract and the promissory estoppel. But anyway, I just wanted to stress this is a very important, powerful tool for subcontractors to open the negotiating door, both in private works and public works. Okay. So now you've got in mind that you have to condition your bid. What are the conditions that you're going to put in there? We've got a laundry list of about 9 different issues to talk about. Probably one of the biggest is the indemnity. And this is where the subcontractor could be caused to indemnify or protect the general from its own negligence. Typically, in the past, this has been a Type 1 indemnity that says, you subcontractor have to protect me, general, even if I'm actively at fault, anything I do, except for my sole negligence or willful misconduct. Okay? What I'm suggesting you put into your subcontract bid is language that says, our indemnity will be only to the extent of available insurance. You're giving them something, or subcontractor shall defend and indemnify only to the extent of fault subcontractor causes. Now this is probably more consistent with what's new in the law, which is SB 474, which just came effective January of this year, which SB 474 was put forward by the legislature, Senator Evans, Eileen Evans, who actually is going to be at our conference on April 24. She's the author of the bill. I had a chance to, as ASAC chairperson, to chat with her staff a couple of times about this bill as it was going forward. And the purpose for the bill is so that every person is responsible for the loss it causes. So if I cause a problem, I should be responsible. Same for you. And that means that if I cause a problem, you shouldn't be forced to protect me from my fault. And that's the heart of the 474 rule. Is Type 1 indemnity is no longer allowed in any construction project in California. That's public works or private works. Owners, there's two exceptions, and that's for homeowners and self-performing GCs or owners. Owners can't get indemnity, GCs can't get it, generals can't get it, and subs can't get it. If you've got a sub-tier guy, you can't get the sub-tier to protect you from your own act of fault either. Now there's a little twist in the law. If you're an owner, you can get the general to provide a complete defense against alleged negligence by you. Why the legislature allowed that, who knows. But the owners can get a full defense. A general, if a general tries to get a subcontractor to provide a complete defense, that's prohibited under the law as well. There's a mechanism in the law that allows a subcontractor to choose either to provide his own attorney to defend the general contractor or to pay a portion of the general contractor's attorney bills. It's the subcontractor's choice. And actually what the law says is it's at the time of the claim, the subcontractor gets to make the choice. Now what you'll see is, and we talked about this a little bit before the program, is that there's a number of forms that are coming out and trying to respond to 474 where, and one of them is where the general contractor supposedly causes the subcontractor to make a choice at the time he signs the subcontract form that says, I now choose to pay a portion of you, GC's defense costs, thereby giving up the choice by the subcontractor to provide his own attorney to defend the general contractor. I don't think that's a proper clause. I think that it's up to the subcontractor to make the choice once they know what the scope of the claim is, how complicated it is, how many parties there are, what the cost of defense will be. At that time, they can make a reasoned choice as to which way to go. This applies to contracts and amendments entered on and after January of this year. Contracts and amendments. Okay, well, change orders, as we know, are amendments to contracts. So does any change order after January 1 of 13 apply the anti-indemnity to the whole contract, even if the contract started before January of 2013, or does it apply only to the scope of the change order work? My belief is it depends. Probably if the change order affects, it just adds new discrete scope of work, probably the anti-indemnity is only going to apply to there. If the change reforms the entire contract, so it's essentially a do-over, a restart, or a fresh project in a significant way, then we may have the anti-indemnity apply to the whole contract. But that's probably going to be on a case-by-case basis, mostly probably just to the change work. Okay, SB 474 applies very broadly, public works and private works, to any construction contract. And construction contracts are so broad it includes any structure on real or personal property. Personal property. So I'm imagining if you build a float for the Tournament of Roses parade, it's a structure on a trailer which is personal property, that may well be a construction contract that bars indemnity type 1s from the contract to build that structure on that trailer. This law has a very broad reach. There are a number of exceptions. We'll zip through these pretty close, pretty quickly, but one big one is for privately owned construction where the owner is a general contractor or one of the construction trades. Okay, so if you're the developer and you're taking any of the subcontract forms or you're performing, if you're doing any of the general contract work or taking subcontracts, your contracts can have type 1 indemnities. Okay, so this is a big exception. It has a potential for being a huge exception. Here's how it might work. Is that a developer wants to put up, say, a medical office building. And the owner wants to get type 1s down the road, and the general does too. The general says to the owner, I'll tell you what, give me a 1% ownership interest in the building. And what we'll do is, as part of the closeout procedure, we'll determine to have you buy back that 1% interest at a discount or a premium or for $1, depending on certain milestones or certain bonus criteria that are built into the contract. It's a win-win for everybody because it's some incentive by the owner to the general contractor to perform quickly and efficiently, but it also incentivizes the general contractor, one, to get some bonus money for selling back that 1% interest, and everybody wins on getting the type 1 indemnities. So this could be a huge loophole. And then the other one is for homeowners. Joe Regular, but how many homeowners are sophisticated enough to know about type 1 indemnities anyway, so it's probably not going to be that big of a deal. Another big exception is for wrap-up insurance policies and program contracts. Typically what you see is that in a wrap-up program there's no indemnity allowed between the insureds. A wrap-up program is where a whole construction project has one insurance policy. It's a general liability. The bigger, older projects started to wrap up mostly the comp side of it. Then they added the GL side, and now a lot of the projects are just doing the general liability without the workers' comp component. But it's one policy that covers all the injuries and all the defects that happen on the project, and there's no other policy. In fact, when you're a subcontractor on a WRAP program, your typical insurance policies will say that we don't provide coverage if there's any part of it is in a WRAP. And so you're stuck as a sub. Your only protection for any problem on that job is through the wrap-up program. Well, wrap-up programs are notorious for having gaps. Low limits, say $10 million for a $50 million building that's going to have exposure for at least 10 years. There's also other things like work that's off-site, that if you fabricate, you're an HVAC guy, you fabricate a lot of your materials off-site and they're in transit, all of that work and all that, the value, until it gets on the site, is your exposure. And since it's for a wrap-up program, your own policy may not cover it. And so what we recommend is that when you get confronted with an OSIP project, you've got to make sure that your insurance broker is aware of it, has looked at the policy, check for low limits or other gaps in the insurance coverage, and make sure that they can recommend other programs that can fill those gaps. There's what's called differences in conditions coverage that will fill the gaps in OSIP and CSIP, owner-controlled or contractor-controlled insurance programs. So you want to make sure that you get that looked at by your own broker. So why are wrap-up insurance programs allowed to have Type 1 indemnities? Probably because it's allowing the general contractor to shift down to the subcontractors exposure for big deductibles, self-insured retentions, or losses that are not covered by the wrap. Suppose that the insurance company goes belly up in year 5. You've got 5 years more of exposure, especially if it's say it's an apartment building. And in year 6 it gets flipped into a condo. You got the prior carrier is gone. Your own carrier is not going to cover it because you've got your residential exclusion. We cover apartments, but we don't cover condos. So you're bare for 5 years of exposure on a high exposure project, a condominium. So if that were to happen, the general contractor, now he's got his Type 1 indemnity clause written into the wrap-up program, and the generals, he gets sued, provide complete indemnity and defense for me. He's happy, you're out of business. Other exceptions, anybody's interested in that, drop me a note, we can talk about those. But here's, continuing on in the indemnity, talking about indemnity, this is the AGC subcontract indemnity form that was revised in December 2012. Not only am I a friend of subcontractors, but I'm also part of the American Associated General Contractors. I'm on the LEDGE committee that helped to draft this, or oversaw the drafting of this. I saw some of the early editions of this clause, and basically it's an interesting approach that the AGC took. Basically it starts out sounding a lot like a Type 1 indemnity. We aside from, anything that's greater than allowed by the state of California, subcontractor shall defend, indemnify, save harmless contractor and all of its buddies from any and all claims, damages, cause of action, whatever kind, attorney's fees, losses, liabilities, any kind of nature, whatever. Very huge and broad. Whatever claims arising out of or connection with subcontractors' obligations under the contract. Not if it's caused by, but if it arises out of, it's related to anything that you have going on as part of your work on this contract, you indemnify me. Very broad and inclusive. Okay, well that sounds like it's going to violate SB 474. Well, start out broad, then take away. And so the clause continues on to take away the breadth. It says, subcontractor shall not be obligated to indemnify contractor for claims arising from the active negligence, sole negligence, or willful misconduct of contractor. I think this is protective of the general contractor as allowed by law and backs off only as required by law. This is pushing the envelope. Well done, AGC. But it does satisfy the law, and I think you're probably going to end up seeing a lot of these forms being used. One thing about this, the AGC form has in it the pre-choice of defense. And so I think the AGC is mistaken on that. I don't think that part's going to be enforceable. Which actually, from the subcontractor's point of view, let it be. Because when the general tries to enforce that clause against you later, you've got 474 in your back pocket to say, no, you're going to lose that one. Here's what I'll do for you. Okay? Unfair insurance, SB 474 also addresses the insurance that a general contractor can require from a subcontractor. Now here's This language that you see here up on the screen is what the ASA has proposed in its bid conditions that you put into yours to say this is the level of insurance that we're going to offer to you if we get the job. And this language that you see here is not precise from the ASA. I've modified it a little bit to make it, it's very strong for the subcontractor. Is the general going to accept this? No, but it is a starting point for negotiations. And your fallback position is bring it back to 474 because that's your strong arm back to the general and say, no, I'm not going to give you fully what you want because I don't have to under 474. And that is, 474 says that owners, generals, construction managers, and subs may require from other tiers to allow them or to name them as additional insureds on their insurance policies. But here's the key. But they may only obtain coverage for the acts or omissions of the promisor. Okay, think about that. I'm the general, you're the sub. I can require additional insured status from you only for the acts or omissions of the promisor. You're the promisor. I can't get insurance for the acts or omissions of the promisee. So what does that mean, the acts or omissions of the promisor? Well, that would be my liability vicariously for what you do, or perhaps passively. If I don't stop you from doing something bad, you might ought to have to protect me for that. So this is a limited form of insurance, an amount of insurance that a general may extract from a subcontractor. Now what you're going to find is the typical 2010-1185 insurance endorsement requirement. Every general contractor form that I know of that calls for additional insured endorsement says this is what you have to give us or equal. Well, what this is saying is the highlighted language down at the bottom says this covers any, I'm an insured for any liability that arises out of your work. This form provides coverage for the general contractor's active fault, for ongoing operations, and for completed operations. It's the gold standard, the most protective form allowed previously by law. My position is that as a subcontractor advocate, this is no longer allowed, that a general contractor, if he requires it, does so improperly. I believe also that if he asks for it and you give it to him and the general the carrier gives this endorsement, the carrier will be bound by that contractual promise because the law does not say that a carrier cannot provide this. It says that a general cannot ask for it. Okay? So if the general does ask for it and you mistakenly give it, I think he's entitled to enforce it. So the answer is you have to say, no, we're not going to give this in the first place. Here's a little history. The 2010-1185 has evolved a little bit. In 2001, the original version was 1985. It was revised in 2001 and 2004, and again in 2007. And I don't want to dwell on this too much except for the general might say to you, well, 1185 or equal. Well, that doesn't answer the question because the or equal still gives too much protection for the active fault of the additional insured, the general contractor. Okay. So what are we going to see coming out of 474? We're going to see a lot more OSIPs and CSIPs. So you'll have to protect against gaps in coverage. Make sure that your broker discusses with you differences in conditions. You have to negotiate out unfair premium credits. Because if you get sucked into an OSIP, they're going to say, well, we're saving you money on your regular program, so you should give us the benefit of that. And if you don't give us that information, we'll figure it out for you. And they'll tag you with huge premium credits. The other thing is that watch out for huge deductibles. Say an OSIP program has a $50,000 deductible. I have a broker friend of mine years ago when OSIPs were just starting to become more commonly used for general commercial liability coverage. He says, you know what? We wrote into our program where I can tag every one of my subcontractors for a $25,000 deductible. So that general contractor actually used the deductible as a profit center because he was able on one claim to generate $250,000 in deductible payments, and the whole claim was only $150,000. So that's just something that you have to watch out for, is make sure that there's only going to be one deductible paid by everybody, and make sure that there's an equitable allocation method for determining and then retroactively determining who has to pay it based on actual percentages of fault. Builder's risk insurance. This is another area where you're going to have to protect yourself. I don't want to spend too much time on it. Just the ASA indemnity conditions to your bid has some language in there that says, by the way, if you don't provide builder's risk insurance for the project, then we're entitled to do that and take a deduction off of, or to charge it back to you, owner, general contractor, hopefully then you to owner, for this protection. Because what happens if the place burns down? You're contractually obligated to provide your scope of work, and if your work was destroyed, if you don't have insurance for that, you're going to have to pay for redoing your prior work at your own expense. It's a big deal. It's something that you absolutely have to be looking at. Apartments to condo conversions. San Diego County, a friend of mine says 100% of the condominium projects that were built in San Diego County from 2000 and forward, probably even going back later, 100% of them have been in some kind of construction defect litigation. And I've heard throughout statewide the number is above 90%. You know, how to quantify these numbers is a little bit difficult, but somebody went through all the public records of all the condos in San Diego and did that and found that there was 100% litigation. So what does that tell you as a subcontractor or a contractor? Is if you're doing a condo, expect to be sued. Okay? So, and those lawsuits can be up to 10 years after substantial completion, because that's when the statute of repose finally kicks the plaintiffs out the door. So, well, that's fine if you know that you're doing a condo up front, because then you'd get into a RAP program, because those will not have the residential exclusion. Hopefully the limits are high enough and you'll be protected for the full 10 years. That's another thing that you have to look at as part of the OSIP project, is how long a tail does the policy have? Is it for the full statute of repose? We've seen them where they're only 3 years of completed ops. So you're bare for the last 7 years, and lots of these lawsuits don't happen until year 9. Okay? So this is a big deal. Well, if you know about it going into it on a condo, at least you can protect yourself. Well, what if you think that you're building apartments? I had a general contractor build a set of apartments. He thought, okay, I know that there's condo risk in here. So he was smart. He put in an indemnity clause that says from the developer, I hereby promise that I'm not building condos, that I will not convert to condos, and in the event that I convert to condos, I will indemnify and defend and protect you and hold you harmless from any defect lawsuit that happens in the future. I promise. Okay, so the general contractor goes and builds this apartment building, and lo and behold, in year 3, the owner sells the project and it's flipped immediately to condos. And then in year 5, the lawsuit happens. Well, at least I'm protected. Oh, and the other thing in the promise that the general contractor got from the developer And if I flip it to condos, or it is flipped to condos, then I will provide you an insurance policy, an OSIP wrap-up to protect you on the condos. So he feels like he's secure. He's got the indemnity and the insurance. Whew. Well, the thing was flipped, and then what happens? The developer goes out of business. Ha ha, surprise, surprise. And did he provide the OSIP policy? No. So whose policy is on the hook? Nobody's, because the general contractor's policy has a residential exclusion. So what do we have? We have an alter ego claim against the developer. Okay? This is a very real risk. Whenever you see an apartment building, think condo. You absolutely have got to protect yourself. Developers often gone by the time the suit happens. Insurance coverage for apartments typically excludes condos. Okay, these are the risks. So what do you do? By the way, my office has a special, this is not part of the ASA form. If you want the bid condition form that I've created to deal with the condo conversion risk, let me know. Drop me an email and I'll be glad to send it to you. One of the restrictions that we put, or the conditions that we put on our bid says, okay, for this apartment building, it's a condition of our subcontract that the owner, the general should protect itself and the subs and the suppliers by requiring that the owner put deed restrictions in the title that says there shall not be a conversion to condo for at least 10 years. The statute of repose, if it runs out, then there's a condo conversion, fine, we don't care. So get the deed restriction. Okay, now one other big protection for you, subcontractors, is, well, a buyer typically will not have rights. The original buyer will have rights against the contractor that built. But once that buyer sells to somebody else, the subsequent buyer doesn't have privity with the original contractor and doesn't have the rights against the original contractor. And so we cut off a transfer of those rights by saying that the owner shall not assign any rights against the general contractor to any subsequent buyer. Okay, this is one of the conditions that we put into our agreement. And by the way, sometimes you're educating the general on this stuff, because the generals aren't protecting themselves. They see your bid conditions, they say, what's this about? Then you say you need to have this as part of your deal with the owner. Hopefully they're contacting you before their deal with the owner is set, and so they can protect themselves. And if they haven't, then maybe this is the kind of job that you need to walk away from. Okay? Owner shall indemnify the subs and suppliers in any action following conversion. This is like my buddy who had before. He got the developer's promise to indemnify and provide insurance for what it's worth, right? Shall provide OSIP in event of a conversion. Now, one of the things, there can be protections in having these conditions in the bid. If it becomes part of the contract, especially between the GC and the owner, if the owner fails and breaches these obligations, if the general jumps on it fast enough, he can grab the cash that the owner gets at the time of sale to fund the OSIP and force the owner to put in a fund, perhaps, to take care of some indemnity obligations. So, but the key is to act quickly and grab the funds that the seller receives before the funds are dissipated and can't be recovered.
But what if the owner is not bankrupt?
Well, and that's, yeah, then you're lost. Okay. Get compensated for financing the job. You know, one of our conditions says define what pay when paid is. You know, typically the general says we'll pay you only after we've been paid by the owner. The old form, pay if paid, is no longer enforceable in California because it interferes with the subcontractor's lien rights. But the generals are able to say when paid, and that could be years and years and years down the road. Swinnerton and Wahlberg's form says we'll pay you after trial and after all appeals, even to the United States Supreme Court has been exhausted. Well, that could be 10 years from now. And if we're right and we didn't, if we had a reasonable ground for not paying you, we don't have to pay interest. If we were wrong, then we have to pay you some level of interest on it for the period while it was being contested. Well, who wants to wait 10 years to see whether or not you might get a couple of points of interest, right? So one of the strong conditions on the bid form is that you will pay us within 30 days, period, end of story, regardless of whether or not you've been paid by the owner. Now, if a general is stuck with you, then you may get it. But otherwise, it's something that it's a negotiating point. I put in there a 1.5% interest per month, 18% per year. Go for it. And definitely you should reserve the right to stop work if you haven't been paid. Retention, this is a big one. On public works jobs, it's limited to 5%, but on private works, there's no limitation right now. ASAC is looking at a bill potentially to encourage, hopefully AGC would come along board to provide no retentions in private works either. So far, AGC's been resistant. That's something that may be in the works. So we put in some language in our conditions that says no retention should be withheld, except to the extent, general, if you've been withheld by owner, fine, then you can pass that on to us. Public works is limited to 5%, and that general has to pay within 7 days. Well, why would you want to put this in your conditions? Because it's in the prompt pay statutes anyway. Well, the prompt pay statutes have some wiggle room in there. This is going to take out the wiggle room. It's going to make it firm. The prompt pay statute says within 7 days unless otherwise agreed to in writing. Well, every general contract form has otherwise agreed to in writing saying we'll pay you whenever we get paid, right? So so we would write that specifically into the contract. Avoid scope creep. And this is for your estimators and your contract drafters, is be very precise in your scope. Be very precise in your exclusions. The more clear you are on what is and isn't in there is going to avoid this. Otherwise, every general contractor form is going to say you provide all this scope as required by this section, this section, this section, and everything that's reasonably inferred therefrom and could be inferred therefrom. So strike that language. We don't take, as subcontractors, any design responsibility. Make that clear. I said the general contractor or the owner is going to have our submittals reviewed by their own design professionals. They're going to be stamped by their own design professionals. We are just making recommendations. We are not providing design. We say it expressly. We accept no design responsibility. And we assume no responsibility for code compliance. The design team should give you a drawing and specifications that will comply with code. We should be able to build up your plans to make it be code compliant. We're not going to be responsible unless we see something that we know is non-compliant. We're not going to be responsible if something slips through. If we see it, we should be obligated to tell you, obviously. Cost increases, price fluctuations exceeding 5% between bid and installation. We know that a lot of times your contract could be sitting on the shelf for 9 months before you actually start installing stuff. Maybe a year. Well, if that happens, we know the price goes up, so you shouldn't have to bear the cost of the delay. The owner should. Now, on the other hand, if the owner allows you and will pay you to early procure so that you have everything waiting on the shelf ready to go, you don't install it for 6 months later. If you can avoid the extra cost and the owner will pay for you to have it and store it, fine. That's a potential negotiating point. So how do you get compensated for inefficiencies in the work if the general contractor causes you to stop and start, accelerate? First off is one of our bid conditions says that the general contractor has to take the subcontractor's schedule into consideration. You can build your schedule only on consultation from us. I'm negotiating a contract for a subcontractor, a siding, cedar shingle siding guy right now, with a general contractor, well-established guy. He saw this clause in our pushback on the actual contract negotiations. So this is outrageous. This is overreaching. How can you demand that we consult you on your schedule? I'm thinking, what? How did you determine your schedule in the first place without asking us how long it's going to take, what we need to be, what access we need, how, what work hours we're going to need, how many manpower hours it's going to take? I mean, this is common sense. But yet, some general contractors don't like to be told by subcontractors how they're going to run their jobs, right? Well, a little cooperation can go a long way. So just put it in your conditions. Say, look, we expect that if we're going to work with you, you're going to listen to us about your schedule. Get compensated for inefficiencies as to payment, for changes in schedule, accelerations, owner delays, third-party delays, out-of-sequence work, force majeure. These inefficiencies and delays are going to relate to not only price escalations, which would be handled under your other clause, but with respect to one of the other clauses that this general contractor had a problem with me about was that I said, okay, our subcontractor is going to have continued, unimpeded, continuous access to the construction site, and that we will be able to proceed uninterrupted. Well, general contractor doesn't want to give us that because he wants to say, you guys got to stop here, we've got something else going on, I need you back again next Tuesday. My guy says, no, we want to blow and go. We want to start, and we're not going to stop until we're done. We don't want to demobilize and remobilize. And so we got a big pushback on that, but we're negotiating it out, and we got to a compromise position where we had asked for compensation for remobilization, demobilization, but we did get was an acknowledgement by the owner that says, look, we understand that if we pull you off the job, we may not get you back when we want you, and we may get you back at reduced crews. So we put the leverage, a little bit of pressure back on the general contractor to say, look, okay, your schedule's going to be screwed up if you mess with us. Let us blow and go. It'll be the best for you. Okay? It's a compromise position. It wasn't the best that we could have hoped for, but it's something. But he accepted our condition that he create a schedule in the first place with a consultation with us, which was a big deal. Because I think they've actually already started to work, and it's going really fast. And my guys, our subcontractor's happy. And the general, actually I bumped into the general contractor last night, and he said he was very happy too. So anyway, but not only did the delays cause price escalations, but they cause inefficiencies. And when you're doing your estimating, typically you're going to estimate for straight through, not stops and starts, not moving crews from the 4th floor to the 8th floor and back and all over different parts of the building. You're anticipating some kind of orderly flow. And so when you do out-of-sequence work, moving your crews from place to place takes away productivity terribly. And so you should be able to get some compensation for that if the general doesn't provide you that continuous, uninterrupted, unimpeded access.
So on a bid, you obviously want to exclude trade stacking, especially for those trades that are in the beginning of the job all the way through to the end of the job. Because the electricians, they are affected severely by the trade stacking.
Especially, yeah, I've got a client right now is faced with that right now. They bid on a job that's got a very short fuse. And the unfortunate part of it is that the bid that we submitted didn't take into consideration the long lead time for the materials. And so by the time the materials get onto the site, there's going to be a compact time for the actual construction. Well, the problem with that is that there's going to be craziness going on at that time. We're going to be stacking, we're going to be moving in and out of people's way. Our productivity is going to be a fraction of what we anticipated. So it's actually going to cause us to accelerate and maybe do some extra OT hours. The good thing on our bid for this work, it excluded OT. So if we have to accelerate by doing overtime, we have a real good argument against the owner, the general contractor, to pay us for that overtime work. And so that's, since the contract isn't fully negotiated right now, that gives us some wiggle room. We're stuck with our small price, but we may be able to get a change order for that extra work on the OT.
Devil's advocate on this, though, a general will generally come in that case and state that you have to absorb your overtime because you should have taken into account at bid time your long lead time on your materials. This is what we run into.
Right.
So,
right.
So actually obtaining overtime from the general can be very difficult because it is our responsibility at bid time to know our lead time and make the general aware of that on our bid.
Well, and your counter to that is we did anticipate that. We anticipated that we'd have full access, and the only reason that we have to do the OT is because you're stacking the trades. If you gave us unimpeded access, we'd have no problem. We wouldn't be doing OT. Okay, so you're right. I mean, the stacking of the trades is the big issue. And so if you have an unimpeded access clause in your contract or in your exclusion, now in this example that we're talking about, they did not have that exclusion in the bid. If we had it, then this would be hands down, no problem. Okay? But it's wiggle room for us to argue about, and so it gives some leverage to the subcontractor to maybe get a break on the OT, if not on the price. Okay. Right to terminate if the project goes idle for 90 days. You don't want to have to pull off and then come back and say, you're on to other things. You want to be able to say, no, we're terminating. Maybe if the general wants it badly, they can pay you extra to come back. Warranty back charges. The red language down here, how you avoid expensive warranty back charges is by insisting on a right to repair. Because you can do it cheaper than anybody else. You can make your work right because you know the project already, you know where the problems are, you know how to get in there efficiently to fix it, and you care to. If the general contractor takes over, he doesn't care to be efficient because he's spending your money, not his. So you got to include in your conditions a right to make repairs. Limit your damages. This is hard, but it's definitely language that you want to put in your bid conditions because it gives you something to negotiate over later. Limit your damages to unexcused delays actually caused just by you. You don't pick up anybody else's share. Limit your liability to 5% of the original subcontract value. Now, subs typically don't get away with this, but design professionals do all the time. So it's something to argue. Get the customer to waive consequential damages, especially if there's limitation. If there's LDs, consequential should be waived automatically anyway. I've got a contract right now sitting on my desk where the general wants the LDs. It's the owner wants LDs and consequentials. I said, no. These are inconsistent. You can't have it both ways. PPPs, okay. There's no lien rights on public property. So if you're a subcontractor, how are you going to protect yourself? We like public works jobs because they got the payment bonds. Thank God for payment bonds, right? With attorney fee provisions in it, this is saving our bacon so many different times. But there are no bonds right now on public property or PPPs. There's no stop notices because if the private funding dries up, there's no fund to get. So that we have to have something. So ASAC's Bill 164 requires payment bonds to protect subs, but also as a sweetener for the public entities, there's a performance bond in there. One of our pitches that you'll get to go across the street in Sacramento with is, look, the public entities don't want sticks in the air. They don't want to have a half-built parking structure with the rebar still sticking up because the private financier went belly up and couldn't complete the job. So the performance bond requirement will make the surety step in and make sure that the public entity gets its project done, and the payment bond will make sure that the general and the subcontractors get paid also. It's a big bill. It's an important bill. Please come to Sacramento and support it. April 24th. So thank you for participating and getting off the risk transfer railroad.